This is likely to be a big talking point. The prenuptial agreement may soon lose its power if the courts see fit to change existing laws. This comes as the High Court in Gauteng, in Pretoria specifically, has reserved judgment in an application which would grant divorcing spouses married out of community of property and without the accrual system compensation for their financial contribution to the marriage. Senior Associate from Adams and Adams Attorneys, Shani van Niekerk, joins me now to discuss exactly what this means, along with the implications this application may have. Thank you for joining me, Shani, and good afternoon to you. So your understanding of what it is that is being asked for in this particular application, just for the correct framing in the minds of our viewers.
Good afternoon. I think where we should start is to determine who will be affected by this matter. There are three marital regimes in which you can be married. It is in community of property, out of community of property with the accrual, and out of community of property without the accrual. Now it's this last section, married out of community of property without the accrual, that will be affected, possibly affected by this matter. The applicant went to court and asked that a 7-3 redistribution claim be extended to also apply to marriages instituted after November 1984. A redistribution claim means, despite the manner in which you are married, despite your contract stating that you are not entitled to any assets from your spouse, a court has the discretion to make a redistribution and grant any assets or any sum of money to be transferred to that party. The court will take into account two very specific factors: contributions made towards the other spouse's estate directly and indirectly. And the indirectly is where the catch lies, because an indirect contribution could be driving around children, supporting your husband, supporting your wife in their business endeavors. And a court will then have a discretion to determine what percentage or what asset that spouse will be awarded for that contribution.
Sure. What a great explanation of what this is all about, and I commend you for it. I had a go at it, Shani, a bit earlier on at the start of the show, and believe me, I found myself in knots and entangled in my understanding of what's at stake here. So for the common person who has, the basic terminology in terms of understanding the marital regimes that we have, the effect of a judgment in favor of this applicant would be that basically we would move from what many people understand as what's yours is yours, what's mine is mine, if we divorce after having been married out of community of property and not having had the accrual system in play. So that would effectively change. What's yours is yours, what's mine is mine.
That's exactly what will change if this matter is successful. And I think what we should remember is that is exactly where the pitfall and the con of this matter is. Should this matter be successful, what does your antenuptial contract then mean? And how would people now, deciding to get married now, which choices must you make on how to get married now, which contract to sign, and how to protect your assets should this matter be successful?
How significant a change would this be, Shani?
Absolutely groundbreaking. It will open the floodgates to litigation, where usually it's women who would not have a claim should they be married without the accrual will now have a claim. And the factors that the court take into account are quite limited if you look at direct or indirect contribution. And one of the factors that has come through case law is the duration of the marriage. However, what will happen, we do not know.
And is this born out of a concern that women in particular are usually left high and dry after having contributed significantly to the growth of the estate of the other spouse during the time that they were married? Does that continue to be the case, that women are usually left high and dry after many, many years in a marriage?
Unfortunately, it is still true that in the majority of the matters that we see, it is women that then walk away from a 30-year marriage with nothing. However, I have clients where it's the woman who has amassed a great fortune and it's the husband who stayed at home, looked after the children, drove the children to school and did all of that. So the scales are turning. Women are becoming empowered every day.
And I also saw that part of what is being argued here by the applicant is that, in a way, she was left with no choice but to enter into this marital regime where it was out of community of property and without the accrual system being in play. Basically, she is arguing that she went into this with, weaker bargaining and negotiating powers. It probably wouldn't have been the marital regime that she would have chosen. It just got me thinking, how frequent does that happen? How frequently does it happen that people find themselves view themselves as not having any choice but to enter into this marital regime, which in the long run could turn out to be disadvantageous to them?
I think that the problem is not a lack of choice, but a lack of knowledge. I have clients that sit in front of me after a 10, 20, 30-year marriage, and they still don't know what the agreement means that they signed. They don't know what it means to be married in and out, with accrual and without accrual. So regardless of the choice being available to them, they frankly just did not understand what that choice meant or entailed. And I would recommend that young individuals getting married seek legal assistance and understand what your antenuptial contract means. And even parties that are contemplating a divorce or are already in a divorce, seek the assistance of attorney and find out what your antenuptial contract says, because that would be the starting point of any divorce.
All right, that's sage advice there. Thank you for that time and your insights there, Shani van Niekerk from Adams and Adams Attorneys. I'm pretty sure we will have the conversation when the judgment is finally out, when the High Court in Gauteng has handed down its judgment in that matter, which, in the words of Shani, would be groundbreaking if that application were to be granted.